everyone, my name is Mike Jackson. Welcome to IAML's alert on OSHA's new record-keeping and retaliation rules. We are joined by Patrick Miller. Pat Miller is a member in Sherman Howard's Labor and Employment Department. He assists clients in developing and implementing safety and health programs in the workplace, including OSHA and MSHA required policies and general employment programs. Pat routinely defends citations before the Federal Occupational Safety and Health Review Commission, the Federal Mine Safety and Health Review Commission, and numerous state plan occupational safety and health boards. Pat, thanks so much for joining us today.
Thank you very much. Thank you, everyone. Today I'll be talking about OSHA's new record-keeping and anti-retaliation rule. The rule was announced on May 11, 2016, and in my view contains some provisions that drastically alter how employers have to deal with their safety and health requirements when it comes to reporting injuries and anti-retaliation. There are two components of this new rule. The first is the electronic submission of logs that are required to be kept by OSHA, and the second one is OSHA's new anti-retaliation provisions. I'll take each of those in order. The first provision relates to the electronic submission of OSHA records. The new rule does not change any requirements with respect to how employers fill out their OSHA 300, 300A, and 301 logs. However, it does add new requirements for certain employers to submit these logs electronically to the agency. For employers who have 250 more employees per establishment, they will now be required, once this standard takes effect, to submit their OSHA 300, 300As, and 301 logs to OSHA annually. For employers who have fewer than 250 employees at a particular establishment, they will be required to submit their annual 300A logs electronically to the government every year. The rule states that OSHA will be providing a secure website for the transmission of this information. However, we have not received any new details as to the logistics of how these submissions will be made. The rule does allow for certain redactions to be made to the OSHA 300 information, such as the redaction of employee names, addresses, and healthcare provider information. Given the bugs that have to be worked out with this new website by which employers are going to submit this information, there's quite a lead time in preparing for the implementation of the rule. This portion of the rule takes effect on January 1st, 2017, and the first deadline for the submission of information is July 1st, 2017. However, this July 1st, 2017 deadline relates only to the submission of OSHA 300As, which are the annual summaries of workplace injuries and illnesses. The requirements for the large employers, the 250 plus per establishment employers, for the submission of 300 logs and 301 reports don't take effect until 2018, with those forms being due on or before July 1st of that year. However, beginning in 2019, all of these forms will be due by March 2nd of every year. Some of the problems we see with this portion of OSHA's new rule are that it's publicly available. Once these records are sent to OSHA, anyone from labor unions to plaintiffs' lawyers to the media will have access to this information. And the problem that creates is that OSHA 300 information is not always indicative of whether an employer's workplace is safe or not. Every injury or illness that is what is known as work-related has to be placed on this log, whether or not it was the result of any fault of the employer. So the concern from an employer's perspective is that this information can be used to distort the safety record of particular employers. And this is part of what we're calling OSHA's name and shame game, and is consistent with the agency's efforts in recent years to regulate health and safety through shaming employers. We've seen it in terms of press releases, Now we're seeing it in terms of forcing employers to make this information available to the public. So that's the first portion of this new rule. The second aspect of this new rule, which employers believe may even be more troubling, relates to anti-retaliation, or as OSHA deems it, employee involvement in record keeping. Anti-retaliation has always been a part of the OSHA Act. In the statute itself, it's Section 11C of the statute, employers have always been prohibited from retaliating against employees who participate in safety inspections, who make safety complaints, or who otherwise are involved in safety and health measures. What this standard does is take some of those prohibitions and put it into the OSHA citation and inspection process. The requirements of the new standard are that employers inform employees that they have the right to report workplace injuries and illnesses, and that they may not be retaliated against for doing so. That's pretty standard. That's something that is not new to employers, nor is the requirement that employers have to inform employees as to how to report workplace injuries and illnesses. So far, so good. What this new rule adds that we have not seen before is the requirement that employers have reporting procedures that are quote-unquote reasonable. The language of the standard says that you must establish a reasonable procedure for employees to report work-related injuries and illnesses promptly and accurately. The problem is OSHA does not define what a reasonable policy is. All they say is what a reasonable policy is not. And they say a procedure is not reasonable if it would deter or discourage a reasonable employee from accurately reporting a workplace injury or illness. So what this standard does, it's what is known as a performance-oriented standard. It basically puts the ball into the court of the employer to determine what type of procedure is going to be reasonable. And the problems we see with this are it leaves a lot of interpretation to the agency's discretion. And what we're going to be seeing routinely in an OSHA inspection is OSHA compliance officers are going to be looking at employer reporting procedures and making a determination if they think it's a reasonable policy or if it's one that would deter a reasonable employee from reporting an injury. And where this is going to come up, there are a couple of areas where this is going to come up. The first is in safety incentive programs. Many employers have programs that incentivize workers to not have reportable injuries. An example would be if a particular shift or group of employees goes X number of days without a reportable injury, there's some sort of monetary reward. That's a common example of what we would call a safety incentive program. OSHA is taking the view, and they've taken this view for some time, but particularly with this regulation, they say those sorts of incentive programs on their face are retaliatory because they discourage employees from reporting workplace safety and health injuries. In other words, an employee thinks, gee, if I report this injury, my group is going to lose the monetary reward. I'm not going to report the injury. So OSHA is taking the position that these sorts of incentive programs are retaliatory. So we're advising employers to take a close look at any type of incentive programs and make sure that any benefits that you give to employees aren't tied solely to recordable injuries. It's good to have other things in there along the lines of if you have so much participation in safety meetings, or if you raise safety issues X number of times, you are entitled to this benefit. It's a good idea to really keep your programs not tied solely to reportable injuries. The other area where this new rule is going to impact is drug and alcohol testing. The standard itself does not speak to drug and alcohol testing. However, in the preamble to the standard, OSHA has made it very clear that they view certain post-accident drug and alcohol testing policies as unreasonable and maybe even deterring employees from reporting injuries. And what they particularly take issue with are policies that require drug and alcohol testing after each injury that takes place at a work site. Their theory is that if employees know they're going to get drug tested after every injury, regardless of the cause, they might be dissuaded from actually reporting the injury. The example OSHA gives is a bee sting. If an employee reports a bee sting, it's very likely that drugs and alcohol were not involved. If the employee knows that he or she is going to be tested, they may not report that work-related injury. The problem that we see with OSHA's position on this is that employers just do not know if drugs and alcohol were involved in an incident until they do the testing. So we think that this reading of the rule and the purpose behind this rule is not consistent with what OSHA is saying with regard to drug and alcohol testing. I think employers should be able to and are wise to test employees following any sort of accident to see if drugs and alcohol were involved. OSHA does say that to the extent that such testing is required by other statutes or regulations, you obviously can go ahead and do it. But they are saying that drug and alcohol testing in every case could run afoul of this new standard, and we think that could be quite a problem. So one other new aspect of the standard is the prohibition against discharging or discriminating against employees for reporting work-related injuries or illnesses. As previously mentioned, this sort of prohibition has always been on the books through Section 11C of the Occupational Safety and Health Act. However, under that statute, the procedure has always been for an employee to make a complaint to OSHA, for OSHA to investigate the complaint, and if they feel that the law has been violated, for the Department of Labor to file a lawsuit on that employee's behalf alleging retaliation. What this new rule allows for is for anti-retaliation cases to now be part of the OSHA inspection and citation process. So employees who now believe that they were discriminated against for reporting an injury can pick up the phone and call OSHA, and an OSHA safety and health compliance officer will come out, do the investigation, and make the determination as to whether or not the employer engaged in retaliation. And what employers will see now, rather than the Department of Labor having to file a lawsuit, which has always been the case under the statute, employers will now be faced with receiving citations that say you have, for example, terminated employee X for reporting a workplace injury or illness. Now, not only will a fine be attached to that citation, but as abatement, which traditionally abatement is fix the hazard, fix the machine that's not guarded, fix the fall hazard that hasn't been dealt with. Now, under this rule, we're going to be seeing abatement that calls for reinstatement of an employee who is discriminated against, or potentially even back pay to an employee who's been terminated for reporting a workplace injury or illness. So this really takes what should be a safety and health inspection into the realm of an HR inspection. And in my view, OSHA is simply not equipped to be doing this. These cases will be heard by administrative law judges of the Occupational Safety and Health Review Commission, who do not normally deal with matters of employer motivation when it comes to making personnel decisions. So in my view, this is a clear attempt to circumvent the procedures of Section 11C, which OSHA has never liked and has always believed that are not strong enough. Now that it's in the citation process, this really gives them more power to enforce anti-retaliation. So in my view, this portion of the standard could be a game changer. It's going to force employers to get their HR team more involved in safety and health matters, more involved in OSHA inspections, and otherwise more involved in the process altogether. So we'll have to see how this plays out. This portion of the standard does take effect soon, August 10th of this year, 2016. So employers now need to be looking at their policies when it comes to reporting injuries and illnesses, making sure they're reasonable, and really taking a close look as to how they handle incentive programs, post-accident drug and alcohol testing, and making sure that their policies are enforced fairly and consistently. So time will tell how this new standard plays out, but there's a lot to keep in mind with respect to the new standard that has recently come down. That's all I have this morning. I appreciate your time. Thank you very much.
Pat, thanks so much for your time. That was a lot of great information. If anyone has any questions, please feel free to reach out to IAML directly. You can ask any questions directed towards us at info@iaml.com, or you can contact Pat directly. Is it okay if people email you questions, Pat?
Absolutely. My email address is pmiller@shermanhoward.com.
Great. Thanks, everyone, for listening. And, Pat, thanks so much for your help today.
Thank you, Mike.